right, so
Do it.
welcome everyone. Thank you so much for joining for today's presentation on common law separations advanced topics. My name is Stephanie. If you haven't met me already, I'm an articling student at Russell Alexander Collaborative Family Lawyers. So in today's presentation, our panelists will be discussing the following topics that are displayed here. There will also be a question and answer portion at the end of the webinar. So please do keep in mind that the content of this webinar is to provide you with general information on separation and is not considered legal advice. So now it's my pleasure to introduce our hosts for today. From the Greater Toronto Area, we have Russell Alexander, Michelle Mulchan, and Bill Rogers from Russell Alexander Collaborative Family Lawyers. So Michelle has been practicing family law for over 10 years. She's skilled in all areas of family law, including divorce, property division, child and spousal support, family responsibility office, the list goes on. So her focus is on creating comprehensive creative resolutions for family law matters. And Michelle excels at helping clients deal with complex financial issues that arise as a result of separation. Bill is a managing associate at our firm. His courtroom experience includes numerous motions, several full-blown trials, and he also had the privilege of winning a major family law victory at the Ontario Court of Appeal in 2014. When he's not practicing law, he loves spending time playing music with his band, Soul Custody. And if you watched the presentation from before, you will know that the name is pending a change because of the changes to the Divorce Act.
It doesn't have as good a ring to it, though. Sole decision-making responsibility.
It just doesn't. It's just not the same.
I'm going to write a letter.
Please change the terminology back so my band sounds good again.
Custody was such a great word.
Bill, you're living in the 70s, man.
You got that right. So is my picture.
Oh, your high school profile picture, high school book.
All right, and last but not least, Russell. He's the founder and senior partner of Russell Collaborative Family Lawyers. With over 20 years of experience, Russell offers a wealth of knowledge and expertise in collaborative family law. He uses his experience with a client-focused approach by creating unique solutions for each of his clients to enable them and their families to move forward with their lives in a compassionate and collaborative manner. So now that you know a little bit more about our team and what we have on the agenda for today, I'm going to pass things over to you, Russell, to start the presentation.
Great work, Steph. Thank you for those kind introductions. Let's launch our first poll and get at it. We want to find a little bit about our audience and who you are. So if you could please take a minute. What makes our presentations, in terms of the feedback we're getting, really fun are the poll questions to try to learn what our audience is thinking so we can kind of tailor our subject matter. This is an advanced course. We do have introduction to an introductory program on this, and the video is going to be made online, but we're talking about some advanced topics today. So let's see what our audience is all about today. Law professional interested in learning more, 80%. So yeah, a lot of legal professionals here today. Another professional interested in learning more about the topic, 10%. Currently going through separation and divorce, 6%. We still have our law student hanging in there, our two students. Thank you guys for watching today. And one other anonymous one, so you can put that in the chat so the presenters know. Thank you for participating in that poll. So let's get at it. Bill, definition of spouse, what are we talking about?
Well, the Family Law Act, Russ, says, of course, if you're married to each other, you're a spouse, but you don't have to be. If you live with someone for not less than 3 years, then you become a spouse. Or if you have a child with the person and you're in a relationship of, quote, some permanence, unquote. Not sure exactly what that means. There's lots of case law, but you don't have to be married is the main point.
Does the toothbrush come into play for the some permanence?
Yeah, the all-important toothbrush. If you move in, the 3-year clock starts ticking. There was that recent case in 2020, Climans and Latner, where they didn't live together, but they were spouses. And it was different. I mean, he proposed to her. He gave her a 7.5 carat engagement ring. She accepted his proposal. They introduced each other to the kids. They held themselves out as a couple. So yeah, they didn't live together, but for all the reasons I just mentioned, they were held to be spouses. But mostly it's when you live together.
That case is going to be in our show notes. Apparently, they both had their own separate residences as well, right?
Yeah, they spent a couple nights a week together, but vacations too. But again, 7.5 carat engagement ring.
Yeah.
What happens if it's a 6.5 carat?
Well, that's a different issue.
That's where the judicial discretion comes
Yeah.
in, Michelle.
Yeah. No, it's got to be at least 7 carats.
Well, the late great Phil Epstein used to say, once the toothbrush shows up, you probably have a spouse on your hands, right?
Yeah. And when the floss shows up, you definitely do.
All right, so I think we're going into our second poll of the day. Can that be? I love these polls, 2 in a row. All right, so we got, does being married make a difference whatsoever to spousal support?
I probably just answered that one, didn't I?
Well, no, we still have some wiggle. Well, I guess it's a binary choice. Yes, it's easier to get spousal support if you're married. No, being married makes no difference.
That's right.
Provided you get the 7 carats, right, Bill?
At least 7.
7.5.
Oh, 7.5 now. You're at 6.5, Michelle, 2 seconds ago.
I said 6.5 is the cutoff point. I don't know.
Oh, okay.
Yeah,
7
it's so
to
big,
me.
she couldn't lift her arm.
7.5, Michelle Mulchan saying it's a certainty. Or you could just sell the ring, right, if you don't get the
And
support.
they were engaged, I think is the point.
Okay.
And they held themselves out.
All
I
right.
remember that case. There was a lot
Yeah.
of travel as well. They did a lot of
travel.
together, even though
A lot
they
of
didn't
money.
live together as often.
Is that the one where they had the wine budget too? Like as part of the financial statement, monthly wine budget?
I'm not sure, but I'd certainly like to see the financial statement.
Yeah. All right. Well, let's see if our audience agrees with us. So, almost split. Yes, it's easier, 53%. No, being married makes no difference whatsoever, 48%. I wasn't expecting that.
You don't have to be. That's why they should call it alimony, like they do in the U.S.
Well, what's
Get
the
the word
difference?
spouse out of there.
Where's the distinction, Bill?
Alimony sounds better.
Then you can get your pets getting alimony and all the rest, or what?
Yeah.
Yeah.
Has there ever been support ordered to a dog?
Good question.
I haven't seen it, but
I haven't seen it.
Dog
I bet you
support.
somebody out there is crazy enough to argue it.
The dog
Yeah.
support guidelines. All right, we're diverging here. You can tell it's late in the day. Let's keep focus. Let's spousal support revisited. So again, we took a look at this in the introductory session that we have a recording available for you. We're going to take a little bit of a deeper dive. So Michelle, what are we looking at here?
I don't think it's me, but I'm happy to chat always.
Are we talking about
Spousal support revisited. That might be you, Bill.
just the different resources we've got?
Right.
I think they're in the show notes. We've got a couple of podcasts available in the show notes. There's some stuff on YouTube, again on the show notes, and those are really good resources. There you go, right there.
Right.
Now, should we move to slide 14?
Yeah, property claims.
Yeah. Okay. If you're not married, and this is called common law separation, so it's not about married people. If you're not married, you don't get equalization. You make a trust claim, which the big one these days is joint family venture. And there's also resulting trust, constructive trust as well. I'm going to talk about pensions and valuation dates in a second. Before I do that, I just wanted to give, if we can go to slide 15, unless that is slide 15. There it is. I like to talk about the history of trust law. It goes back.
Where are we going, Bill? How far back are we going?
We're going back 1,000 years, Russ.
Trust Law 101. Am I back in law school, guys?
Yeah.
Magna
Trust
Carta
law.
or
It started
How far back
1,000
ago?
years ago. 1,000.
we only have 1 hour. Okay, just
Yeah.
let you know.
Well, I
But
wanted
go
to go
ahead.
over every year individually in depth. But trust law is the reason that we have that you can share property even if you're not married. And basically, trust law is is part of what they call the law of equity, which is the law of conscience, the law of fairness. It actually started out as a church court in England 1,000 years ago, the Court of Equity. And trust law basically means, this is the way I look at trust law. On paper, I don't own it, but in the eyes of God, I do, or at least I own some of it. That is the key to trust. You're not the legal owner on title, but you make a trust claim and the court will say, yeah, your partner's the legal owner on paper, but you deserve an ownership interest to this in some portion or other.
Does that tie into the Crusades somehow?
According to Wikipedia, it started with the Crusades because people would leave England, property owners would leave England to go on the Crusades, and they'd have to sign their property over to their friend because I guess they weren't allowed to own property and not be there. And then when they came back, their friend would not give them their land back, so they'd make a trust claim and say, you know what, he was holding it in trust for me. That's how it all started, according to Wikipedia. Slide 16 has the resulting trust. It comes into play. It's not that common. Basically, the leading case is called PECOR, P-E-C-O-R-E, Supreme Court of Canada case from 2007. Resulting trust basically is if you transfer property and or money to someone gratuitously, in other words, it's just give it to them and you get anything in return. And then later you want to get it back. The law says you can, unless the person you gave it to can prove you intended it as a gift. If they can't prove that, you get it back under the doctrine of resulting trust. But again, the main trust law that's used nowadays for common law relationships is called the joint family venture, which everyone's heard of. And before I talk about that more, which is in a bit, we're ready for poll 3.
Great. All right, thank you.
Talking about a joint family venture, hallmarks, and then we're going to talk about the hallmarks after the poll. So maybe some people will know these.
Let's see what our audience is thinking. Which one is not?
One of these is not relevant to a joint family venture.
So we're going to give them a moment. I want to answer a question that came in. Everybody, please send in your questions through the Q&A. This is interesting. How do you quantify spousal support claims of shorter than 3-year cohabitation?
You don't get it. It's got to be 3 years.
And there's a child. Let's throw a child in there.
Unless you have a child that's of some permanence.
Yeah.
Good question.
I think
I guess divorcement would do it. It wouldn't be much.
Yeah.
The duration wouldn't be that much. I don't think.
The relationship with some permanence and get past that first before starting to quantify.
Yep.
Quantum, duration, things of that nature. I think it would be a pretty detailed analysis. You'd have to really show the court that there was a really good reason for it.
Yeah, that's right.
I think the facts are going to drive that, right? We don't know where the child is residing. The child might be residing with the support payer.
Yeah.
And he or she may have greater expenses for care of the child, which would supersede, in my view, a spousal support claim. But it's going to be a fact-driven exercise, right?
Fact-driven for sure.
Yeah. Great question. Thank you for sending it in. Let's see what our audience is thinking.
Yes.
So
most people got it right.
Location of the parties. I think that's spot on, right, Bill?
Did I make up that poll? Because that's just dumb. Why would that be important?
So the parties, even if they reside in the UK, it's not relevant? Is that what you're saying?
No, that's not what I'm talking. No, then it would be under Ontario law. You're starting to confuse me.
You're doing great, Bill.
Location.
All right. Let's get into the fun stuff. This is where we're seeing a lot, if not a majority of the claims being made before court, even in collaborative settings, the joint family venture. I'm going to kick this one over to Michelle and see if she kicks it back at me or if she's going to take it on. What do you think,
Am I
Michelle?
allowed to kick things back at you, Ryan? All right. So yeah, the joint family venture, really there are 4 hallmarks, and we've already gone through it in the poll: mutual effort, economic integration, actual intent, and priority of the family. And these are all fact-based. These are all very specific. We call them hallmarks or indicators. So number 1 is the mutual effort. So this is things like, did the parties work as a team? Did they make joint decisions together? What decisions did they make in the past, and how did they make it? Did they make a decision to have children, to raise children together? How did they decide where the kids went to school? Private school, public school, Catholic school, public school. There's lots of different choices and decisions that families have to make. So how did they do that? Did one party do it by themselves? Did both parties make a mutual decision? Even things like extracurriculars could be looked at when it comes to a trial or a decision on these issues. The next thing is economic integration. So a really big one: did they have sole or joint bank accounts? Right? That's a really good look at what they were doing. Who paid for what expenses? Did one party pay for everything? Did both parties pay for everything? If there's a home, what account did those expenses come out of? Did one party maybe pay the mortgage and one party paid the property taxes? Or did they have a common pool of savings, right? If the parties put all their money or a portion of their money into some sort of account, and then that's the account that they used for renovations or vacations or things like that, that's going to show some demonstration of economic integration. The third hallmark is actual intent. So was there an intent to share the wealth that they jointly created? And did they view the relationship as equivalent to a marriage? So it's difficult to determine intent. And again, you really look at that particular family and what's happened there, and how, what decisions were made and why. So for instance, I had one case with joint family venture where one of the parties, Bill, you may remember this one, had actually produced a copy of birthday and Christmas cards that used the term husband and used the term wife. And the judge was interested to see that.
Yeah.
I also had another party who had a massive celebration for one of their big anniversaries, and it was very akin to what you would see if you were a married couple at a 20th or 30th or 40th anniversary. And they had photographers and pictures together, and both sides of the family were there. They got monetary gifts from both sides of the family, and they pooled those resources, and they used it for a joint vacation, kind of like a honeymoon, but more of an anniversary moon. So then you look at the fourth hallmark, and that's the priority of the family. So, sorry, I think they're asking for people to mute while not speaking to help with the sound. So for the priority of the family, does one person rely on the relationship for future economic security? So let's say, for instance, you had one party who has a baby. What does the other party do? Do they support that party while they have a baby? Is there maternity leave? How long is that maternity leave? How did they make that decision? Was that a joint decision, or did one party simply say, okay, I'm going to take a year off? These are all things that the court will look at. What happens if one person becomes unexpectedly unemployed? Did the other person pick up the slack? Did they both continue to contribute equally to the relationship? Did that unemployment change how they structured their finances? What happens if there's a relocation? Let's say one of the parties got a really great job opportunity. Did the other party consent and move? Or, was there a discussion about how that would be dealt with? So again, these are all, it's very much fact-based, and these are all ideas of things that a court can look at, but ultimately it's your relationship and that history of that relationship that the court's going to look at. And I think one of the things I really want to highlight here is it's not necessary to have all of these hallmarks. It's not a checklist. It's not that you have to, get every single one of these boxes. Again, the judges are going to look at all of the factors and all of the history, and they're going to make a decision based on that. And really, from my personal experience, every single joint family venture case I've had is completely unique. And I think it takes a lot of time and effort and sitting with your client and having conversations about, hey, let's go back. Let's go back to, let's say they had kids. When you started to have kids, how was that decision made? When did how long did you talk about it? Did you think about it? Even things like, how did you tell your families about it? These are all things that you would want to do as a litigator, to sit down and figure out how to best present your client's case. One important thing about a joint family venture is assets are often valued at the date of the trial, not at the date of separation. So that's a really interesting, sometimes different from married couples. And we have this case, Gonzalez versus Scrimmager. And in that case, the court decided that the subject property would be valued at date of trial, not date of separation, which is really interesting, because if you look at the last year or so, we've had so many fluctuations in property, in valuations of homes. So that can really cause a big difference. Let's say today I'm having a conversation with a client. We may take into account that in a year or two, when you're going to a trial on this, we may not know what the value would be at the time.
When we talked about this 6 months ago, that was really important because property prices were going through the roof. That spread between date of separation and date of trial could be potentially $200,000-$300,000 even more. And now it looks, well, they're saying on the news this morning, Toronto real estate prices have dropped by 20%. So it could be a situation where the home's worth less than on the day of separation. So it's sort of a double-edged sword. Has some great questions coming in. Sorry to cut you off there,
No,
Michelle.
go right ahead.
Can you make a joint family venture claim even if the parties are married? Phil?
Yes, you can, and often do.
Are you going to face the argument, though, that the Family Law Act sets out the legislative scheme for equalization?
Well, there's a case from 1990 called Rawluk, Rawluk, which established very clearly that you can have both in the same case. You can do a trust claim and an equalization claim. And the reason you do that is equalization only goes from the date of marriage to the date of separation for asset value. So if you want to get at assets, asset growth that occurred before date of marriage, you have to bring a trust claim. Or if you want to get at asset growth that occurred after date of separation, you have to bring a trust claim. So yeah, people do bring both quite often, and yeah, you can.
Limitation period for joint family venture?
Well, I'm glad you asked that, Russ.
I hope I'm not stealing your thunder. Were you going to talk about that in a moment?
That was that big case I did in 2014, McConnell and Huxtable, which I totally lucked out on and won. Russ, are you riding your motorcycle?
Okay. Yeah, I'm on the side of the street here. So go ahead.
The limitation period for a trust claim, which includes a joint family venture, if that trust claim targets real property, and they almost always do, is 10 years. If it doesn't target real property, it's iffy. But if it does, 10 years, so it's good. That's a good thing. That's what McConnell and Huxtable did.
All right, great to know. Thank you for that, Phil. Any final points on this before we move on, Michelle?
No, I think that's great. Thanks so much, Russ.
All right, so let's talk a little bit about constructive trust.
Okay, thanks, Russ. A joint family venture is a constructive trust. The difference is it is not asset specific. So a constructive trust, it goes back to that Becker and Petkus case from 1980. And it was a constructive trust about a farm, and only about a farm. That was it. It didn't go after any other assets. I'm not sure there were any other. The point is, it was specific to the farm. Joint family venture, again, is not asset specific. It goes after global increase in wealth for any asset. Doesn't that, you don't have to. So that's really the only difference. Other than that, it's the same thing. And then it has, of course, the hallmarks Michelle discussed, and that's important. But you could theoretically make a constructive trust claim individually about every asset you can think of, and then you'd have the same thing. But why bother? You can just do a joint family venture, global increase in wealth.
So joint family venture, what I hear you saying, would include claims of constructive trust.
Well, it's a special kind of constructive trust that's not asset specific, but it's the same logic. It's the same underpinnings as it's a trust claim that says, hey, I don't own it on paper, but in the eyes of God, I should.
All right. Financial statements. This is who we got here, Michelle?
So financial statements. So really interesting matter. How do we deal with financial statements when there is a common law couple? So we know that there is the forms 13 and forms 13.1, and technically you're supposed to use a form 13.1 if you're married and if there are equalization claims, and a form 13, technically people would argue that should be used for a common law couple rather. But my practice, honestly, is to go straight to the 13.1, unless maybe I'm the party who doesn't want to share, but that could be seen as being a little bit sneaky. Quite honestly, the courts are going to want to see it anyway, and the courts are going to order it. So why waste the time? Why waste the money? Why play games? I think it's in my practice, I would rather provide disclosure and then have a judge make a decision on everything than try to spend the time having motions or arguing over what can be done. And quite honestly, you're wasting a lot of the client's money unless you have a really, really, really strong, good claim, and you could get that without having both documents. Some people like to do both. And it really, I think, is, again, as we're going to say a lot in this course, fact specific, and really just depends on the client you have and what the claims are. Otherwise, the financial statement process is all the same. You want to make sure you've got the sworn financial statement. My practice is to have a full disclosure brief. I like everything tabbed and everything hyperlinked very neatly. So when you're looking at my financial statement, if it says that there was $330,000 sitting in an account somewhere, I'll have a little tab A, and that tab A, if you go to my disclosure brief, will have that bank statement with that disclosure. I think it really helps judges. It also gives judges confidence that you know what you're talking about when you're specific and when you're detailed like that. It also helps me because, cases are difficult and there's a lot of complexity to each case. So if I have a judge asking me, hey, Ms. Mulchan, where did you get that number from? It's very simple for me to be able to cross-reference, especially on case lines. You can actually, if you wanted to, you can hyperlink. I mean, it would take you a long time, but if you're going to a trial, it would be a good option for you. You could hyperlink your financial statement to your disclosure brief to have that readily available for when you're presenting. And the other thing I really like is with respect to financial statements, I like a lot of notations in them. So for instance, I will, if there's an inheritance claim, for instance, I will put out how the money was paid, when it was paid, when it went into the account, what account it went into, if let's say the account numbers changed over time or they switched investment counsel, whatever it is, I would put all that there, because the last thing you want is a judge saying, oh, Ms. Mulchan, this was put into account ending in 365, but now it's ending in 367. What happened, right? So again, the more you could do, the better it is, especially because joint family ventures are very fact specific. It's very evidence-based. And you want to make this as simple for a judge so that when they're sitting there making a decision, they're not scratching their head trying to figure out how you came up with these numbers. It's clear as day. So that's really my topics on financial statements. Did we get any questions on that, Russ?
I'm just going through them now. One question came in, a couple questions about this subject matter. What is the limitation period? When does it start for joint family venture, Bill?
Well, it's again, it's 10 years if real estate is one of the targets, which it almost always is. When does it start? That's a really difficult question to answer. Typically, it's the date of separation. Even though they're not married, that's usually when they would start that. So you got 10 years.
That makes sense because that's the date you should realize you potentially have a claim.
Yeah,
Right?
absolutely.
If you're still living together, you think everything's fine, right? You're not
Right.
contemplating what your rights are on separation unless you entered into a domestic contract.
Yeah. So basically, 9 times out of 10, it's going to be data separation, and it's going to be 10 years.
All right, great
And
stuff.
that makes sense because it would be possible for someone to have a joint family venture claim on, for instance, something that happened prior to marriage, but then the marriage was longer than 10 years. That person should not be automatically precluded from bringing a joint family venture claim for something.
Yeah, good point.
All right, so I think we're moving into parenting. Any volunteers, Michelle?
Sure, Russ. So parenting is the exact same for married people as it is for common law people. It really is the best interest of the child. It's a prevalent test. We all know that it seems so long ago because of COVID, but in 2021, we changed our language and we've moved from custody to decision making and from parenting time to, I can't even remember the old terminology, from access to parenting time. And really what the courts are going to want to see, regardless of whether you're married or common law, is what's in the best interest of the child or children. We have a whole webinar on parenting and self-help and how people make decisions for children and how children are affected by these decisions. And all the courts really want to see and hear is how is this going to affect the children and is this in their best interest?
All
And we
right.
have some show notes actually that we're going to be sending the link to that podcast if you're interested in hearing it.
All right, so is it time for a poll? Possibly.
It's been a while, Russ. I'm surprised
All
there wasn't a
right.
poll before.
I know, we got 6 in this morning in one session, but we're only at poll 4 now, but let's see what our audience is thinking. Are common law couples entitled to CPP division upon separation? So there's a bit of a typo in our poll, but it's, are common law couples entitled to CP division on separation? Any questions you want to tackle during in the Q&A, Bill or Michelle, while we're moving on here?
Here's an interesting one. Is a married spouse entitled to spousal support if separated and still living in the same matrimonial home? Wow, what a loaded question.
I've had that come up. I think so, but it's weird. Like you're paying someone, like I guess you could just hand it to them every month.
We see this a lot where the person who would be required to pay support is probably carrying the expenses of the home.
But if the person's still living there, like would you have to pay them support?
50% of those expenses would probably be close to
Yeah.
a support claim. But what's the purpose of your support? Where's the need, right? If assuming you're in the home and everything's still status quo in terms of bills, groceries.
It sounds very much fact dependent. Like if the person's lifestyle plummets because you're not giving them money anymore the way you used to, then maybe then you'd have to
Right.
at least give them something.
I love Excel and I like doing these little calculations of, hey, if we were to ask for spousal support, then they're going to ask for half of the, mortgage, property taxes, the Section 7s for the kids, the property insurance. So, it's a worthwhile exercise to maybe look at. And you're right, Bill. I think there are some instances where if one party has all the wealth, one party does not. And even though you're living in the same home, they've, maybe cut off access to an account, or maybe one party, and this happens often, scooped all the money from a line of credit so that no one has any money to live on, then that may be a successful claim. But I think, as you both said, fact specific.
Got one for you here, Michelle, that just came in. How many times does a financial statement need to be updated?
Per the rules, you're supposed to do it at the beginning, and then every single time there's an event, unless it's been less than 30 days. But also, I find that sometimes there may be life events that cause the financial statement to be changed. So let's say there isn't a court event, but you have one party whose child is starting post-secondary education and there's now a greater need. It might make sense. So I like to do more financial statements than less. I think it shows the need. It also shows the court that you've been keeping the other party abreast of all the changes. So the other party can't come back and say things like, oh, I didn't know the kid was going to post-secondary, or, oh, I didn't know that hockey was that much money, even though the kid's been in rep hockey for 5 years previously.
Sometimes it's just done by way of an affidavit, right? Updating the changed circumstance. It's not necessarily a full financial statement, but if there's been a change, you need to notify the other side, and especially the court if you're before the court.
Oh, absolutely. We will often do affidavits for small changes, like including your updated income. At the beginning of the year, once you get those T4s or income tax returns, there's an obligation to provide them to the other side and to the court, so everyone's updated. But it may not affect, the rest of the financials.
Right. Let's see what our audience thinks of CPP credits. Are they entitled common law couples? 32% yes, 29% no, 39% it depends. Almost split down the middle there. What's the answer, Bill?
Well, I'm not sure about CPP, but other pensions. Do you know the answer, Russ?
Well,
On
why don't we go
CPP?
into our next slide?
Yeah,
Because we're going to talk about this.
Yeah,
It's a nice lead into pensions.
yeah. Other
Yeah.
pensions.
Yeah, let's talk about pensions and common law couples.
Yeah.
Because we did this program, I think, a year or two ago.
Yeah.
I had never seen a case to divide a pension, and
Yeah.
I didn't think
It can
I didn't-
be done.
I didn't think there would be the deprivation you need to show, but I was proven wrong. One of our audience members sent us some cases. So where are we at, Bill?
Yeah, well, there's 4 cases. I think slide 27 or 20. Yeah, there we go. There's 4 cases. This one, again, not married, joint family venture, and the pension was divided here. Granted, it was an uncontested trial. We can move on to the next slide. Again, unmarried, but the pension was divided. Mind you, it was only the court had ordered a payment, and the pension was divided only after the man failed to meet the deadline for that payment. So, but it was divided. Next slide. This one, the pension was not divided because there was no link. And with a joint family venture, you must always show a link, a clear link between the claimant and the increase in wealth. And in this case, there was no link between this guy and his wife's pension. Similarly, in Raleigh, the next slide, once again, pension not divided because there was no link. So yes, you can attack a pension in a joint family venture claim. There has to be a good link between you and the person who was working and accumulating the pension. There's a link between you and that pension growth. It can be done. I would say the chances are not great, but it can be done.
I really like this question that came in from our audience. We have anything else on pension, Bill? All right, so let's run our poll, and then I'm going to get to this audience member question. Keep the questions coming in. These are excellent questions. Should the Family Law Act be amended to provide for common law couples to share property like married couples? Give everybody a moment to answer this poll question. So this question is a notional tax deduction to be applied to the liability section on a pension? If yes, what's the percentage that you use for calculating? Well, I think there's a number of things we need to explain. First of all, what's a notional tax deduction? And secondly, can you apply it to a trust claim to a pension? What do you think, Bill? I like this. This person's really thinking it through, and I
Yeah,
got my own opinion, but I want to hear your answer
yeah.
first.
My guess would be, I've never done it on a case like that, but my guess would be, yeah, you could apply that once you've established that there is a link between the claimant and the pension. Then why wouldn't you subtract the notional tax? I think you would.
It'd be unjust if you didn't, because
Yeah.
married spouses apply, so you
Yeah.
should have the same or equal rates as married spouses. So great question. Just throw this out there. Think about applying, this is a common law topic right now, but if you're married, think about applying notional tax deductions to date of marriage assets to reduce how much people can exclude or deduct from the sharing. All right, so let's see. Sorry, you want to add into any of that, Michelle?
No, it also depends on how the pension is being paid out. If it's a direct payment to a LIRA or a different pension plan, then you wouldn't include the notional disposition tax. But if you're doing it kind of like an equalization where you put it in the NFP and then there's a payment in cash or whatever it is, then you would. And with respect to the percentage, wow, we can spend an hour talking about that and arguing about that. And I think we've all spent an hour arguing with other counsel about that. But usually I think if it's a high net worth, it's better to get a proper valuation done and then that number set. You're not spending days at court, at trial rather, arguing about what that number should look like.
Ballpark, probably low 20% would be 22, 23 I've seen in some cases. Get an actuarial to do a calculation for you, even a 2-page report estimating the tax rates and making various assumptions. But that's generally the range. But you're right, if it's a high income earner, that might be closer to 40 or even 50%, depending on who's receiving it and what the tax rate's going to be. Okay, so let's see what our answers are to this. Yes, share everything, 33%. Yes, but share only the home only, 15%. No, don't share a thing. They were not married, 40%. Or other, 12%. Well, there's an argument, right? If you're getting married, you're entering into certain contractual obligations and legal obligations pursuant to the Divorce Act. And some people choose not to get married because they don't want to have those obligations. So I think, the majority answer here, probably there's some argument to it. I don't think it's going to carry the day. I think judges are leaning towards sharing everything. But what do you think, Michelle?
Well, we've been on both sides of this, and there are so many reasons to and so many reasons not to. I think in the end, I think it is going to be a share everything, simply because the resources that have to be spent and the time and the money by clients that have to be spent to make this joint family venture argument is really hard. And I think that it's also unpredictable. So one of the things we tell our clients is, look, we can argue the best we can for you. We can make it as detailed an argument as possible, but it really just depends on what side of the bed the judge woke up on that day.
It depends how much you're arguing over, right?
Oh,
if it's $20,000 or $30,000, clearly that's going to be eaten up in legal fees. If it's multi-million dollars, it might be worthwhile to take a run at it, but you could be subject to costs too. Your thoughts, Bill?
Sorry?
Your thoughts on the poll results?
Oh, sorry. I thought you said, have you heard of costs?
Oh.
What are costs?
It's what you put in the parking meter when you're outside the courthouse.
Well, I mean, I understand the idea of creating that law. It makes sense, but then we won't be able to talk about the Crusades.
True. So let's look at legislative and other reforms. The late great Phil Epstein advocated back in 2010 at a conference in British Columbia that Ontario should really enact legislation to deal with these common law claims. The amount of uncertainty and resources that are spent litigating these claims and the drain on the court system is significant. Plus, it's difficult for lawyers and other advisors to give any certain advice, right? There's always a bit of a risk. You never know how the facts are going to play out when you conduct your trial. The other party may be very sympathetic to the judge, and he or she's going to lean over backwards to come up with a result that they think is fair, and it's an equity, right? So you're right, Bill. It's depends on what judge you draw that day and what kind of mood they're in, and so it's a bit of a crapshoot. So I think legislative changes would certainly enable lawyers to provide more meaningful advice to their clients and certainty, and I think that would enable us to negotiate settlement of these claims much more effectively. We're not going to get these big gaps, all or nothing. Are you going to divide the house, which is usually every family's biggest asset, or is it not going to be divided because you're common law? You're talking millions of dollars now, right? If you look at the housing market in Southern Ontario. We're seeing more and more judges are very unlikely to side with the one spouse and not share anything. But again, it's fact driven. Michelle, what's your take on legislative changes? The court's making it through common law, but should the government step in and legislate this area?
I think so. If you look at current wait times for trials, I think post-COVID we're at about 2.5, 3 years, right? Personally, I've done a number of, not trials, we settled them all, but a number of matters where we spent multiple conferences dealing with this issue. And, maybe what we do is a presumption of sharing, but you can try to rebut that presumption if you have really strong evidence to the contrary. And what I'm specifically thinking of is, I think the 3-year relationship is a pretty good test, but also you can have people who were together for 3 months, had a child, and you have parties now claiming this joint family venture. So I think there would need to be some strong language and some really good a really good section outlining what's going to happen, when it's going to happen, and what can be used to rebut that presumption.
All right, thank you for that. So let's go on to, I think this is our final poll of the day, but we got 6 in, so that's completely respectable. Can unmarried spouses sue for the tort of family violence? Domestic violence is plaguing our society. Certainly, participants in the family law justice system are very mindful of this. It's really sad issue that we need to address. And there's some case law that we're going to get into that talks about this issue, but let's see what our audience thinks and see what the results are. Can they sue? No, 3%. Yes, 88%. Very sophisticated audience today. Yes, but the damage award will be smaller. Yeah, let's get into this because there's lots of interesting questions that arise out of torts and damages. And you want to take the lead on this one, Bill?
Yeah, Russ. There was a case recently that established a new tort, the tort of family violence. It used to be
I think we have a slide on that case. There it is. Yeah.
That's it. A versus A. It used to be initialized, but now if you look on Canley, they actually have the names. I guess they've changed that, so it's Alawalia versus Alawalia. It is under appeal, but the way it stands now, the woman was awarded $150,000 for her claim. The court did say, just a couple of points, the court did say this was rare and unusual situation, and so you have to keep that in mind if you're going to try to bring a claim like this. It's got to be a really bad situation. The interesting thing about the tort of family violence, if you read the judgment, the judge talks a lot about this tort is different because it's not a single incident, like a car accident or somebody fell. It takes place over a long period of time. And that is the interesting, it's a long, the language is long-term harmful patterns of conduct that are designed to control and terrorize. So it's a elongated tort. And the other interesting part, there was a lot of violence in this case, but there was also coercive control, which is a new thing that's actually came out of California recently. Now it's here, and it's been actually specifically enumerated now in the legislation as a example of family violence. And again, the coercive control it's not one incident, it's a pattern that goes over time. And in this case, it was part of what this guy did. He had complete financial control. The wife gave him all of her earnings. The court mentions as late as 2011, she did not even have a cell phone. He repeatedly threatened to leave her and leave her and the children penniless. He would subject her to weeks and months of the silent treatment. So that is a good example of coercive control. It's an elongated thing that takes place over a long period of time, and it's terrorizing. I mean, you're being told you're going to be left penniless. You don't even have a phone. The silent treatment, that's a form of torture in a way. So that is the case that talks about it, and again, it is under appeal. I think it's going to be affirmed personally, but we'll have to see.
Yeah. Interesting strategy considerations, right? Do you bring this as part of your regular family law action? Or do you hire a civil litigator to commence it? I suppose you could commence it in civil court, but I think it would be the realm of the family court if you're dealing with other issues at the same time. Strategically, what do you think there, Bill?
It actually, if you read the case, the court actually does say, if you're going to bring a tort action, bring it in the family law case. They want it to be done all at once, one-stop shopping. So yes, do it together. Do not start.
That avoids potentially inconsistent decisions of Superior Court judges, right, on findings of fact.
Yep.
What the family court may find this happened, in the civil court they might find a different finding of fact.
Yeah, they want it done together in one action.
All right, thank you for that. Michelle, what's your take on these torts?
Yeah, I mean, such a horrible, sad situation. Just even reading the analysis that the judge did, you get a bit of a glimpse into what this poor woman endured and suffered. She was an immigrant. She had young children. There's, outstanding criminal proceedings against the husband. The children were estranged from the husband for years. I think that it's great. I love that it opens up, it opens this up for people who are experiencing domestic violence. I think it's still going to be a hard thing to argue and to prove. And as we know, working with people who are unfortunately the victims of domestic violence, they usually try to protect the person who is causing the violence. So it's going to be harder to prove. But I think it's one of those things where we have to empower victims, and we have to ensure that as a court we are creating laws and creating new means of allowing people, not necessarily only women, but people, to move forward financially after having experienced this abuse, because it's going to be hard. They're going to have circumstances and they're going to have a harder time moving forward, finding jobs, being out in the workforce. I mean, this was a 17-year or 18-year relationship. So if you had been subject to abuse for 17 or 18 years, I can foresee that there would be a lot of long-term damage there. So I like it. I think it's great. I think you're right. I think it's going to be upheld with the appeal.
And the other side of that coin is, if you're defending against these claims, right? Some people may bring a false claim. We're seeing more of these claims before the court. You might want to consider whether or not you need to bring criminal counsel in when doing your pleadings, in case there's a criminal charge that's subsequently laid. More to consider, but I see our host is back. Welcome back, Stephanie.
She's kicking us off.
There's so many great questions coming in. I want to leave a lot of time for some questions here at the end. So if you're all okay with it, I'm going to just jump right in. All right,
Please.
so we had one come in a situation of a common law relationship where one party bought the home shortly before the relationship and the other spouse made monthly contributions to the mortgage. Could the title holder argue that this was rent rather than a contribution to the property?
Well, that goes to the issue of deprivation, right? If this person was living somewhere else, they'd have to pay rent. They would be making those payments in any event. But I think, Bill, you're probably going to say it depends if they held themselves out as a joint family venture. How did they present themselves to the community? What do you think?
I wouldn't charge my romantic partner rent.
You're a good man, Bill.
No one would.
You're
But you know what?
romantic.
That's a great question, because that's exactly what they do say. And in a joint family venture, they always, you make a claim, and then from that claim, the judge will subtract any benefits you received. And they always say, oh, you lived rent free.
Well, I think the argument is, though, Bill, no, the person making the claim was paying household expenses. The argument is you're not deprived. You would have been paying those expenses regardless. You would have been renting an apartment and paying cable and buying food. So.
It's a legitimate argument, and it's very fact dependent. But you're right. It's not as simple as what I said, but
well, you can argue both sides.
Very poor taste to charge your romantic partner rent.
And that's the problem, right? Every single one of these joint family venture cases, that is the argument. That is the other side's position. So it would be nice to have some sort of codification of a law that says, hey, this is how you deal with it.
And usually it's you've helped with the kids and you've allowed that person to work and keep paying the mortgage and stuff. That's usually what it is.
All right, so on the topic of the property and the home, how or can you remove or evict a common law partner who has no interest in the property but refuses to leave?
You've had cases, I think we've had several cases like that.
Do not change the locks. That's in very poor taste. Do not do it.
We often see police called in these situations. Sometimes they remove the person, sometimes they don't. You're certainly not going to go to landlord and tenant court because you need to get an order from the family court if it's a relationship. So I think the safest way to go is to ask a court in the family division to make an order, would be my suggestion. What do you think, Michelle?
I fully agree. I mean, that is the quickest way to have an urgent motion and to really make a judge not like you. So, you know, it really depends on the facts. So let's say there was domestic violence and it's the police were called and there was an incident and the person who did the assault was the person who was removed. That's going to be less frowned upon. But if it's a separate situation where there is domestic violence, but it's the person who was assaulted is asked to be removed, I think you are looking at a very expensive court proceeding, lots of motions, and a judge who's really not going to be happy that you took those measures.
It's a tough situation. I mean, if there's no violence, it's just you want to get rid of this person and they won't leave. It's a tough situation. But again, I would try not to change the laws because that just makes it worse.
Yeah.
They'll break the window and come in that way. You know what I mean? Like, it's not cool.
Don't tell Bill where you live. He's breaking in. All right, well, thank you so much. Thank you again to our panel, and thank you to everyone in the audience for taking the time to join us for today's presentation. We do hope you found it helpful.
All right, so I think that wraps up day one. We're back at it tomorrow at 10 a.m., Shannon?
Yes, we'll be starting at 10 a.m. tomorrow again and going until same time tomorrow.
All right, so Stephanie, great job. Michelle, wonderful. Bill, glorious as always. Shannon, great job putting all this together. I know it was a lot of work.
Thanks to everyone who signed up. Really appreciate it. It's an honor to have your attention
today. That's really, thank you so much.
Yeah.
Really appreciate it, and hopefully we'll see you tomorrow.